is that we have pulled various parts of the record into a cross-examination bundle to make it easy to page through it rather than moving from page 1002 to page 2002. Could I just ask my team to put those in front of the panel and in front of the witness, and of course to my learned friends?
Thank you, Counsel. You may.
Thank you. Well, I'm told it's also uploaded electronically. So for those where they don't have individual hard copies, it's accessible. If the panel has file 1 and file 2 of the cross-examination bundle.
I have file, I beg your pardon. I have file 1 and file 2. My sister has file 2, file 2.
All right. No surprises there. Thank you, Chair. I may commence then.
Thank you.
Thank you. Advocate Batohi, I understand that you started as the NDPP on the 1st of February 2019. Is that correct?
That is so.
And in your evidence, you stated that one of the cases that you inherited was an application for the judicial review brought by Major General Boyson against the racketeering certificate, which had been issued by Advocate Sean Abrahams. Is that correct?
That is correct.
Yes. Then you also stated that you instructed a panel led by Advocate Rodney de Kock to review the evidence and to give you advice on the way forward. Is that correct?
That is so.
Yes. Then Advocate de Kock gave you the advice on the 27th of June 2019. Is that correct?
I don't have the report in front of me, but I have no doubt that that's correct.
Yes. After you received the report, you withdrew the opposition to the case.
That is correct.
Yes. Now, there's something that doesn't make sense with this narrative. I presume that the NPA had senior counsel on brief to defend the application. Is that correct?
I beg your pardon, Counsel. You take it slowly.
Thank you.
Take it slowly. The withdrawal of the matter following Advocate de Kock's report pertains to the Katomena matter.
Yes. Yes. Thank you. Now, Advocate Bahato, there's something that I need to get clarification because it doesn't appear to make sense to me. I assume that the NPA had briefed senior counsel to defend the application by Major General Boyson. Is that not correct?
My recollection is that is the case.
Yes. Now, did you take advice from the senior counsel on the prospects of success in defending the application?
I don't think so.
Well,
I'm trying to think back. I'm trying to even think who the counsel was.
Well, I can tell you who the counsel was. It was Advocate Hilton Epstein.
That's quite possible because he was dealing with a number of matters at the time.
Well, I've got this information from Advocate Sean Abrahams. He had briefed Advocate Epstein. Now, you haven't answered my question. Did you take advice from Advocate Epstein or not?
No.
All right.
I don't think so.
All right. And did he give you any written advice?
I can't recall.
Advocate Batohi, it can be no, and you can't recall at the same time.
Well, I can't recall whether he did. And it's difficult trying to cast your memory back a number of years. I know he was dealing with a number of matters, and this is, as you say, one of them. I honestly can't recall whether he did give any advice.
The problem I have is that you've disclosed many legal opinions, and you have not mentioned Advocate Hilton Epstein at all in your evidence in chief or in your statement. So I'm wondering, why have you suppressed that information?
I haven't suppressed anything. I honestly can't remember whether he gave us any opinion on this.
But nevertheless, it seems to me that a responsible NDPP would have asked the senior counsel on brief for an advice on the prospects of defending the application.
In my view, I had the opinion of a very senior, experienced team from the NPA, and I accepted their advice.
I'm talking about before you obtained the opinion of Advocate de Kock. Advocate de Kock gave you an opinion only on the 27th of June, but you had been seized with the matter as soon as February 2019. I'm asking you, you've said initially you did not obtain advice. Later you said you don't recall if you obtained advice, but I'm asking you, it seems the most prudent thing would have been to ask the advocate you have briefed for advice. Why did you not do that?
In my view, the most experienced persons to give me advice on this racketeering issue would be persons in the NPA who are experienced with racketeering. And that is why I decided the most appropriate and reasonable way would be to get not just one person, but a panel of 4 people, very experienced in these issues, to give me a view on this.
Yes. And I just want to make sure that I've given you a fair chance on the question whether you did or did not obtain advice from Mr. Hilton Epstein, because I'm going to ask the panel to give me a chance to consult with him and to ask him whether or not he gave you advice. And you've given so far 2 inconsistent answers. One, I don't remember. Other, no, he did not give me advice. Do you want to consider your position?
No, I really am trying to think about what happened at the time. My initial response was, in fact, I really don't remember, but having thought more, I'm inclined to think that I did not get it from him. But of course, you are most welcome to speak to him, and we will also check our files to see if there's anything to that effect. But we're certainly not suppressing anything.
Now, my instructions are that, in fact, there was a meeting with Mr. Epstein on the 6th of March, 2019, called by you at your office, which included the state attorney, Mr. Sabele Metza. Do you remember that?
I did have meetings with Mr. Epstein.
You did have meetings with
him? It may have, in fact, been more than one, because he had been dealing with a number of matters in the NPA. And so I just wanted an update on what was going on.
Yes, I'm asking you about one meeting, which is the 6th of March, 2019. Not asking you about other meetings.
All I'm saying is that I did meet with him, and that is possibly also a date on which I met with him.
Now, that meeting, I understand, was also attended by Counsel for Major General Boysen, Advocate Anton Katz. Do you have any comment on that?
Unless my memory is failing me, I can't recall having a meeting with Boysen Katz and Epstein. But I'm not saying that it didn't happen, but I really, at this point, I can't remember that.
Well, it would have been a big story on your diary that you have called the advocate who represents the person who is suing the NPA into the same meeting with the advocate who's defending the NPA. I'm not understanding why you cannot remember such a big event.
Well, it may be a big event in your calendar, Advocate, but for me, I meet with lots of counsel, and I cannot recall whether they were both in the same meeting.
So your answer is, I don't remember.
That is correct. I do not remember.
Just like you don't remember if you got an opinion from him or not.
That is correct.
Yes. Now, I am also told that it was at that meeting that you instructed the state attorney to withdraw the opposition to the Major General Boyson application.
What date was that?
6th of March, 2019. I presume you also can't remember.
I can't.
Yes.
I beg your pardon. The answer, if I understand it, is that you don't remember the meeting
No,
where
whether
Advocate Katz was present, or what is it that you don't remember?
the last question was whether I gave an instruction to withdraw the opposition to the review application on that date. And I cannot recall that.
Yes. Can I ask you then, Advocate Batohi, because legal opinions are privileged information, can I ask Advocate Epstein to give me from his records the advice, if any, that he gave you?
This is an inquiry seeking to establish the facts. I have no issue with that.
Yes. Oh, thank you. Because it seems to me, if your evidence is that you only took the decision to withdraw the opposition on the 27th of June, after the 27th of June, that would be fundamentally inconsistent with the facts as they happened, which, as I understand, already that decision was taken by the 6th of March, 2019. Would you accept that?
That would be inconsistent, yes.
Yes. All right. We will come back to that topic after I have spoken to Advocate Epstein. Can I ask you another topic? You have repeatedly mentioned state capture in this inquiry. Do you remember that?
I do.
Yes. Now, the definition of state capture as adopted by the Commission under Justice Zondo is a misuse of the state and its organs for private gain or for unlawful aims. Do you accept that definition?
Yes.
Do you have any personal knowledge that Advocate Chauke was involved in state capture?
I don't have any personal knowledge.
Yes, all right. So then it was grossly irresponsible of you to mention state capture in the context of Advocate Chauke when you have no personal knowledge of his involvement in state capture.
Should I comment on that?
If you want to, I'm putting it to you that I will argue that you were attempting to poison the atmosphere when you had no evidence, but you mentioned state capture together with Mr. Chauke.
The reason why I did is that I was asked about why I took certain actions when I did. And I explained that because that was in fact the NPA and capture of the criminal justice system was something that the Zondo Commission was inquiring into. And I couldn't turn a blind eye to the fact that that was what was being inquired into, and that as a responsible national director, in my view, I needed to consider all options. And the only reason why I mentioned it is because I was asked about the context and why I took certain actions. And that was what was also something that was on my mind at the time. So I considered all of this, and therefore I took certain actions.
Advocate Batohi, we are in an inquiry against Advocate Chauke. We are not in a state capture inquiry. My question was simple. You've given me an answer. You have no evidence that Advocate Chauke was involved in state capture. Yet you have repeatedly mentioned state capture in the context of this inquiry into Advocate Chauke. That is what I am saying to you, is intentionally designed to poison the atmosphere of this inquiry, to create the impression that Mr. Chauke is involved in state capture, when you know full well that you have no such evidence?
I was asked what were the reasons for me doing certain things at the time. And I explained that that was the context within which I took those decisions.
Yes. Anything else to add?
No.
Now, can I then move on to another topic, just to understand these charges? My understanding of the way in which these terms of reference emanated is that you drafted them and the president endorsed your draft. Is that correct?
Well, actually, what happened is we went and checked this after. We did submit a draft to the president, but what the president adopted subsequently is quite different from the draft, and we didn't input into any draft that the president had. So there is a difference between the two.
All right. Well, I have not seen the draft you gave the president. And maybe you should send us that draft, because I understood all along is that the president endorsed the draft that you gave to him.
No, that's not the case. We can let you have the draft.
Yes. Now, can I then go to making sure that I understand?
I beg your pardon. Advocate Batohi, what is the answer? You're saying Advocate Nkabinde can have the draft.
That is correct.
Do you have it?
We do have it.
Thank you, Madam Chair.
Has it been made available to the evidence leading team, that draft?
I'm not sure if it has.
May we ascertain whether the draft document that was sent to the president as regards the terms of reference has been made available to the team? May
Sure.
I just verify with Advocate Mutlamanyani? Has it been made available to you?
Madam Chair, I'm not aware of any draft. All what I'm aware of are the terms of reference that have been gazetted.
Might we find out from your team, Advocate Halley and Junior and the lady next to you, if you probably have the document in your possession? It may also be relevant, I'm not sure at this stage, because you have raised, Advocate Batohi, a question of the correctness of not necessarily that way, because you seek to amend the terms of reference, correct?
That is correct, Chairperson.
That document may be relevant in determining what you conveyed to the state president.
Sure.
May it be made available if you have it? Madam,
We got it.
Advocate Halley and Junior?
Madam Chair, we no doubt will make it available, but my instructions are, and I've got to verify this, but my instructions are that it already is there, but I stand corrected. I would have to verify it myself.
Do you have it though? Do you have the document?
Not at this speed right
Not
now.
at this stage.
Yes.
Are you making an undertaking, Advocate Batohi, that your office will make available the initial letter or document, whatever it is, or a memo to the state president?
Yes, we will.
When will we have the document?
Today, as soon as we are adjourned.
Yes, thank you. Will it help, Advocate Nkabinde?
Yes, Madam Chair, it will help. I still have one more question on the issue of this draft. Advocate Batohi, I want to confirm whether it is your testimony that the draft you gave to the president is different to the terms that the president finally signed.
That is correct.
Yes. And you cannot at this stage tell us what the differences are.
I can't.
Yes. All right. Can we then go to the terms of reference that the president endorsed? Because I am not understanding them. They have been referred to in several parts of the case. Hopefully the panel can access the terms of reference easily.
I'm trying to find my copy, Chairperson.
Do you have the copy,
I don't have it yet.
Advocate Mutlamanyane? Do you probably have a copy that we can give to Advocate Batohi? A copy is now made available.
I do
to
have a
us.
copy.
Thank you.
Thank you. Can you go to item 3.1.1? It reads, the institution of the racketeering charges in terms of Section 2, subsection 4 of the Prevention of Organized Crime Act 1998 against Major General Boysen and members of the Ketumano unit, and the defense of those actions in subsequent review proceedings brought by Major General Boysen to have the racketeering certificates set aside. In that, now there are a couple of points that arise from that. The first one, is that charge limited to racketeering or does it include the predicate offenses?
Racketeering, by its very nature, includes predicate offenses.
Yes, but you know what I'm asking you. I'm asking if the murder charge standing alone is included or excluded. And if I can give you an example to make it easy, Major General Boysen is charged with 7 counts, 2 of racketeering, 2 of murder, 1 of defeating the ends of justice, and 2 of violating the provisions of the Firearms Control Act. My question is a simple one. Does that charge exclude the 2 murder charges, the 1 charge of defeating the ends of justice, and the 2 charges of violating the Firearms Control Act?
As I said, racketeering by its very nature includes the predicate offenses. So it must include the predicate offenses as well.
Advocate Batohi, please answer my question. I am not asking you about racketeering offenses and its elements. I promise you I can read for myself. I'm asking you whether or not the independent charges of murder, the independent charges of defeating the ends of justice, and the independent charges of breaching the Firearms Control Act are included or excluded.
My answer to that is that it includes racketeering charges.
I know it includes racketeering charges because it says racketeering. I'm asking you if it excludes the charge of murder against Mr. Boysen.
It does not exclude it in the context of racketeering.
Advocate Batohi, I think we are going to be here for a long, long time if you don't answer the questions directly. We know racketeering, in order to establish, requires predicate offenses. That's not what I'm asking you. But I'm asking you is that Major General Boysen was charged independently of murder. Is it suggested in this charge that he should also not have been charged of murder independently of racketeering?
That's not what I'm saying. What I'm saying is that I can't, that's my answer, is that the predicate offenses are included in the racketeering charge. And so my understanding is that he would have been charged for those predicate offenses in the context of racketeering.
I honestly do not understand that. And let me give you a final chance. if you withdrew racketeering, Major General Boysen will still face a murder charge.
That's a different question, and I'll answer that now.
Yes,
So
now-
when I did withdraw the racketeering,
No, I'm not asking you to answer anything. I'm telling you the question that I'm going to ask you. Is 3.1.1 intended to suggest that Major General Boysen should not have faced the murder charge?
not at all.
So you accept that he should have continued to face the murder charge or not?
Can I answer that question?
Yes.
After I decided to withdraw the racketeering charges, I sent all of the dockets back to the DPP KZN and asked her to consider each one of them and whether anyone should be charged with the predicate offenses outside of racketeering.
No, I still don't understand that. I'm asking you about the charge against Advocate Chauke. Whether or not you accept that there was sufficient evidence for Major General Boysen to be charged with the crime of murder or not? Or do you say there was also no sufficient evidence of the crime of murder?
On the basis of the decisions of the DPP KZN, after I sent the dockets there, she found that there was no evidence to justify murder charges against any one of the accused, except in the one docket. And that did not include Major General Boysen.
Yes. Those are later decisions. I'm asking you about the decisions taken by Advocate Chauke. Is it the case of the NPA that Advocate Chauke erred in charging Major General Boysen with murder?
My understanding is that Major General Boysen was charged with racketeering and that those were the predicate offenses.
Yes.
And that is where we say Advocate Chauke erred in supporting racketeering charges.
Yes.
I beg your pardon, Advocate Batohi. Is this question premised on the assumption that Advocate Chauke made a prosecutorial decision to charge?
Yes, I'm working now on the best case for the NPA.
That's why I'm asking the
Yes,
question,
no,
because all along, when we read the opening address, it seems to me that there was an issue regarding whether he made a prosecutorial decision
Yes.
in relation to the Katomena matter. My understanding of the evidence favorable to you was that Advocate Chauke was appointed merely as a coordinator in relation to the KZN Katomena matters.
Yes.
That's why I'm asking the question as to whether you premise this question on the assumption, at least for now,
Yes.
that he did
Yes.
make this particular
Yes.
prosecutorial decision
Yes.
as regards the charge of murder against Major General Boysen.
Indeed. I'm working now, Madam Chair, on the best case for the NPA, that Mr. Chauke has taken all of the decisions they claim. I'm trying to understand the substance of the complaint, but I will still deal with whether he did make those decisions or not. So I'm still trying to analyze the charge. Let's come back then, Advocate Batohi, to understand what 3.1.1 is about. You have said that your understanding is that murder featured only because it was a predicate offense, not because it was an independent offense. Is that correct?
It was a predicate offense to racketeering, that's correct.
Yes. And therefore, it is irrelevant to Section 2, subsection 4 as an independent offense. It is only relevant as a predicate offense.
That is correct.
Yes. All right. Now, the reason I'm asking you this is because even on your own version, you've accepted that at least in relation to one of the charges, there was sufficient evidence to prosecute. Is that correct?
No, I'm not understanding you.
Well, you've told us that you gave all of the dockets to the DPP of KZN. She enrolled one case against Mr. Padiache on a count of murder. So she must have considered that there was sufficient evidence to charge Mr. Padiache with murder.
Yes, I didn't realize you were referring to that docket. That's correct.
Yes. So that's why I come back to say, in at least one of the cases, there was sufficient evidence to proceed with a murder charge.
That's correct.
Yes. Now, that distinction is not made clear at all in 3.1.1. If you read 3.1.1, it suggests that in none of those cases, there should have been a charge.
Against Major General Boyson. That's what that suggests.
No, that is false. It says Major General Boyson and members of the Cato Manor unit.
Let me read this carefully.
Mr. Padayache was a member of the Cato Manor unit.
The point I made earlier is that this related to racketeering charges. And therefore, it's clear here that this section is relating to racketeering charges and murder as a predicate offense and not as separate independent charges. And so it's correct in that regard that it is racketeering. It doesn't refer to murder at all.
Yes, I thought we had moved from that question and we were debating the independent charges. And I asked you a question, whether you would accept that in at least one of the dockets, the case against Mr. Padiache, there was sufficient evidence to charge. And I understood your answer to be yes.
That was my answer.
Yes. And when I proceeded with that, you said, well, exclude Major General Boyson. And then I pointed to you that actually exclude all members of the Cato Manor unit.
The point I make is that whether it's Major General Boyson or all members, this particular paragraph refers to racketeering charges and not independent murder charges.
Yes. Now, could I then ask you to turn over the page? 3.1.1.1 refers to supporting a decision to prosecute the accused. Who is the accused?
All the accused in the racketeering charges.
Yes, that's where we come back from, where you say no evidence justifying the decision. And now we understand that you would accept in relation to one, that there was evidence justifying a murder charge against Mr. Padiache.
But not a racketeering charge.
Yes, I understand.
Anyone.
You've made that clear. I'm asking you a different question. Was there sufficient evidence, in your opinion, having studied the dockets, if you did, to support a murder charge against Major General Boyson?
There wasn't.
There wasn't. Now, you gave evidence earlier that you did not study the dockets and you relied on a memorandum by Advocate de Kock. Was that evidence accurate?
That's correct. But my answer now also relies on the evidence of a report of the DPP KZN.
Yes. I'm not asking you about the DPP KZN. I'm asking you, at the time you took the decision to institute a disciplinary case against Advocate Chauke, you relied on the report of Advocate de Kock. You never studied the docket. Is that not correct?
That's correct. I didn't, let me just check the time that I decided. No, that's correct. I didn't study the dockets, the 23 dockets.
Yes, I'm asking just the docket around Major General Boysen. 2 murder charges, 1 charge of defeating the ends of justice, 2 charges of violating the Firearms Control Act. Can I tell you, Advocate Chauke read the docket. Did you know that?
I would have expected him to.
Yes. But you have come to say to the panel, there was no case against Major General Boysen without ever having read the docket. Can I suggest that that is an astonishing proposition coming from the head of our prosecution service? And I'm going to tell the panel that at the end, that your evidence must be rejected as incredible because it is irresponsible to make such a claim without having read the docket.
It's not irresponsible at all, and I'll explain why. There's case law that national directors are not expected to read every single bit of evidence and every docket in cases, and that they are, it's perfectly acceptable for a national director to rely on reports, to rely on presentations, to request aspects of evidence, and to take decisions on that basis. So it's certainly not irresponsible. It is what is expected of a responsible national director.
Yes. But can I also suggest something else to you? That Section 2 of the Prevention of Organized Crime Act is within the exclusive power of the NDPP. Do you accept that?
I'm not sure what you mean by exclusive power, but
Well,
certainly
only the NDPP can sign a racketeering certificate under Section 2, subsection 4. I would have thought that to be obvious.
certainly I agree that only the national director can sign that authorization.
And exclusively the NDPP. No one else can sign a racketeering certificate.
That's correct.
Yes. Now, it's in that context that I say, for you to tell the panel that there is no case against Major General Boysen, also of racketeering, without ever having studied the docket against him, is a grossly irresponsible thing.
I repeat what I said.
Of course.
There's case law that states that a national director is not expected to read every docket and to look at every piece of evidence before coming to that conclusion. A national director, it's permissible for a national director to consider evidence that is presented to him or her by a team, presentations, and to ask for specific aspects of evidence if he or she requires it. But it's certainly not expected of a national director to read every single docket in any context. Sometimes a docket can fill a room, and it's certainly not expected that that is what a national director should do.
Well, can I challenge you on that and put 2 propositions to you? Firstly, the docket against Major General Boysen does not fill a room. It's a small docket. Do you accept that?
I'm not sure that there is a docket against Major General Boysen. I know that there were 23 murder and other related charges, dockets. I'm not sure that there ever was a racketeering docket as such.
Now, you see, the problem is that you answer, but you always overlook what you wrote. Go to 3.1.1.1, where you say, supported a decision to prosecute. I mean, I know you say it's the president who says this, but you never wrote this, or you don't know the difference, so I will accept that until I see what you wrote, your answer remains qualified.
Mm-hmm.
That there was no evidence justifying the decision, and that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. You are the one who relied on case dockets. Now you are telling the panel there was no docket.
I said there were dockets, lots of dockets, but I'm not aware of a racketeering docket as such.
No, Advocate Batohi, I think there is a real problem. You have said that 3.1.1 is exclusively about racketeering and does not include the independent offenses. And you have also confirmed in 3.1.1.1 that too is exclusively about racketeering. The charge refers to case dockets. What case dockets are those?
Which charge refers to case dockets?
Read 3.1.1.1.
Yes, it does appear there.
It was put there by you.
I'm not sure about that. We'll have to check that.
Yes. But then answer my question, please. The docket that is referenced, we have gone through this exercise ourselves. It is only 7 charges against Major General Boyce. It is not the exaggerated docket that fills a room. What do you say to that?
The only point I made about dockets that fill a room is to make the point that it is not expected of a national director to read every bit of evidence when a decision is made. That's the only reason why I mentioned that. But getting back to this issue, there were dockets relating to, there were the 23 case dockets. I'm not aware. Let me read this carefully before I answer this. This is clearly incorrect, because to say that he sought to improperly have the acting director of public prosecutions of KwaZulu-Natal sign the case dockets. It's not our case that Advocate Chauke asked the DPP to sign any case dockets. So this is clearly incorrect. And
so the charge is incorrect.
If I may be allowed to complete.
Yeah, all right, sorry, I thought you had finished. Please continue.
It's okay. And or the prosecution memo. He sought to improperly have the acting sign the case dockets and or sign the prosecuting memo. If you read it like that, it's incorrect. That is not what we're saying.
So charge 3.1.1.1 is a wrong charge.
It's incorrect.
Well, incorrect and being wrong are the same thing.
Well, part of it is correct, is that Advocate Chauke supported a decision to prosecute the accused, notwithstanding that there was no decision, justifying no evidence, justifying the decision. And then the next part of it is incorrect to the extent that I've indicated.
You see, that's why I need the memorandum you gave the president to see whether the president is at fault for charging Mr. Chauke incorrectly, or whether you are at fault but are now escaping responsibility.
I'm trying to explain as best I can and not to escape responsibility.
Yes, no, I understand that. I'm not criticizing you, I'm criticizing your evidence.
It's fine.
Now,
Before you proceed, I think this will also help us, Advocate Batohi. When you look at the gazetted terms of reference, the date is the 30th of September, 2025.
I don't have that gazetted copy in front of me.
The front page
Oh,
of
there you
the
go.
Gazette.
I have it now. Yes, that's
Regulation
correct.
Gazette number 11889, volume 723, 30 September 2025, number 53444. You
That's
have
correct.
that. When did you see for the first time the gazetted terms of reference?
I'm not sure, Chairperson. I can't recall when I saw it for the first time.
Should I assume that by 1 October 2025, you had already looked at the terms of reference?
No, we can't assume that, Chairperson.
Should I assume that by the 17th of October, when this inquiry started, I beg your pardon, by 17th of November, when this inquiry started, you had already looked at the gazetted terms of reference?
Chairperson, I honestly can't remember when I looked at it and whether I scrutinized it at any great detail or cast a quick look through it. I honestly cannot recall that.
When you took oath, the first day you took oath, had you already looked at the terms of reference?
Chairperson, on the first day of the inquiry,
On the first day you took oath,
I would certainly have had a look at it, but I don't know to what detail.
you may proceed, sir.
Just one thing. Advocate Batohi, when the bundles or documentation was prepared for this inquiry, it was prepared with a view to addressing issues raised in the terms of reference. Is that correct?
I'm not aware that it was prepared for that specific purpose.
Did you care to establish as to whether the documentation was prepared for that purpose?
No, I didn't.
Sorry, a follow-up. Advocate Batohi, when you prepared your affidavit together with your legal team, you knew that you were preparing an affidavit to come and testify in relation to the terms of reference in this inquiry?
I knew that I was preparing an affidavit in order to come and testify before this hearing.
Testify in this inquiry in terms of the terms of reference, wherein you referred a matter to the president, who then constituted an inquiry and issued the terms of reference to deal with whatever you referred to the president.
Yes, the terms of reference were for the panel, and of course, evidence was going to be provided to support what's in the terms of reference by various witnesses.
Advocate Batohi, when you prepared your affidavit, you prepared your affidavit to sustain the allegations that you made to the president, which, well, I'm not sure whether rightly or wrongly, convinced the president to constitute a panel. But the president depended on the evidence or on the information that was supplied by you, which you intended to support by way of an affidavit that served before this panel. Is that correct?
I didn't prepare the affidavit with an intention to support the terms of reference. I prepared an affidavit on the basis of what I knew and what I did in this matter. It's not like I prepared the affidavit and then checked whether it's aligned with the terms of reference.
And-
That's
and-
not what
and-
I did.
And what you knew is what you submitted to the president for the president to take a decision to set up an inquiry.
That's correct.
Thank you.
Thank you, Madam Chair. Advocate Batohi, I'm not yet done with this inquiry about case dockets.
Mhm.
You have now testified that the reference to case dockets and trying to get someone else improperly to sign is incorrect. Okay, I'm not going to quibble with that.
Mhm.
But do you accept that the case against Major General Boysen, whether contained in a docket or elsewhere, is a fairly narrow case? It is not the example that you posed of a docket filling up a room.
It's certainly not a docket that fills up the room. That's correct.
Yes. Now, it also continues to say, and or prosecution memorandum.
Mhm.
That's one of the things I don't understand. You never gave evidence in this inquiry that Advocate Chauke sought to have Mr. Molotra sign a prosecution memorandum. Is that also incorrect?
I mentioned earlier that is incorrect.
Yes. So both that case docket reference and the prosecution memorandum are wrong.
It is not our case that Advocate Chauke sought either of those to be signed by Advocate Molotra.
Yes. Now, then it continues to talk about evidence implicating the accused. Who is that accused?
I would imagine it's all the accused.
All of those accused with what? Because there are people like Mr. Mostert, 11 counts of murder. Does it include them or not?
For racketeering charges.
So all of the accused on racketeering.
That's correct.
Yes. Now, the way then it would read is that the case docket would be a case docket for racketeering. The prosecution memorandum would be a prosecution memorandum for racketeering. But because the charge is wrong, we can strike that out. We can put a red pen across that.
Can you repeat that?
I'm saying the way it would read before your evidence today, the way it would read would be it's the case docket for racketeering. And then it's the prosecution memorandum for racketeering. But because you have now considered that that is a wrong charge,
I have a case docket for racketeering. I'm aware of a lot of other dockets, the 23 murder dockets and related charges. I don't even know if there was a case docket for racketeering. So I don't understand your question.
well, my question is exactly linked to what you have just said, that you've charged someone for trying to get a signature on a case docket that you say doesn't exist. You've also charged someone for trying to get a prosecution memorandum to be signed, which you admit was never done.
I have not charged anyone for that.
All right.
I did
see.
indicate that that is definitely not the case, and that is definitely an error on that, because there's no evidence at all that Advocate Chauke was required to do any of these, either sign a case docket or sign a prosecution memo.
Yes.
The evidence is that he sought Advocate Molotra to sign the indictments.
Indeed, there is not a single charge here that refers to an attempt to sign an indictment.
That's
If you can
correct.
see it, show me.
That's correct, there isn't,
Yes.
and it's not meant to be, because
Yes.
there's no evidence to that effect.
No, I thought you said the case against Advocate Chauke is that he sought to have Advocate Molotra sign an indictment.
That's correct.
I am saying to you, there is not a single charge here that refers to Advocate Chauke attempting to get Advocate Mulochwa to sign an indictment.
That's correct. I'm not aware of the other, if it's anywhere else on this, but
But
certainly
you
not
can go
in this.
through them now. There is enough time. And then show me where it is alleged that Advocate Chauke sought to have Advocate Mulochwa sign an indictment.
Well, it may or may not be there, but that is our case.
Well, Advocate Batohi,
Ju-
please.
Just before you proceed, just one thing. Advocate Batohi, did you familiarize yourself with the terms of reference?
No, I didn't.
And you are the complainant in this matter?
That's correct.
Thank you.
Well, you can call me the complainant. It's the president that decided. So I'm not sure that I'm the complainant, but I certainly made a referral to the president.
Which question are you answering now?
Whether well, it wasn't a question. It was a comment that I am the complainant in this matter. And I'm seeking to clarify that I don't see myself as a complainant. It's
Thank
the
you.
president who decided. I made a referral to the president.
Thank you.
All right. I'm going to come back to this question by Madam Panel Member Ramakhaga, but I still want an answer to my question, which is, show me where it is alleged that Advocate Chauke sought to have Advocate Mulochwa sign an indictment.
I accept from you that it isn't. Otherwise, it's going to take me a while to read this entire terms of reference.
No, it won't take you a while. There are only 5 paragraphs. So you can do that now and tell us which paragraph refers to Advocate Chauke trying to get Advocate Mulochwa sign an indictment.
May I, Advocate Nkabinde? It's 10:15. And perhaps in fairness to you, Madam, as we take a 15 minutes tea break, you will go through the terms of reference to enable you to answer the question that Advocate Nkabinde has just asked you in relation to whether there is any referral in the terms of reference, if I capture his question correctly, that appears in the terms of reference in the entirety. And when we reconvene, you will then answer the question. Advocate Nkabinde?
Perhaps, Madam Chair, we can also get the draft, because I want to put her draft and the president's decision side by side. If we can get that during this 15 minutes, that would be appreciated.
Yes, I was going to deal with that. You had just mentioned that the first letter to the president, the referral letter, if I may call it that, is readily available. We will appreciate to have a copy of that letter when we reconvene. You can send it to us either online or a hard copy and give it to our researchers. Advocate Nkabinde?
Yes, if are we adjourning now?
We will adjourn
Yes.
now. Anything else that
Nothing
you
from our
wanted to
side. Thank
mention?
you.
Yes,
Thank you, Madam Chair.
Those two things reflect upon the gazetted terms of reference with a view to answer counsel. Secondly, may we have the first referral document to the president, which you said is readily available or can be made available, so that we deal with this matter when we reconvene. Thank you. We will adjourn for 15 minutes for tea and reconvene at 10:30.
we adjourned, I had asked you to study the whole charge sheet and to tell us whether or not there is an allegation that Advocate Chauke sought improperly to get Advocate Mulojo to sign the indictment.
There isn't.
Thank you very much. Now, can I ask you about 3.1.1.2? It says that presumably you recommended to the then acting National Director of Public Prosecution, Advocate Nomgcobo Jiba, the application for issuing a racketeering authorization in terms of Section 2.4 of the Poker Act, whereas there was no evidence justifying the institution of racketeering charges against the accused. Now, the recommendation that is referenced there, is it the document we went through repeatedly, which is PP'd by Advocate Chauke? I just want to get
Would you
the...
please repeat your question, Council?
Yes, or maybe what is better is that I must just refer to the document
I think
itself.
that will be helpful.
Yes. My Leonard Jr. will find it now. The question really is this. You had a discussion with Madam Ramachakha about whether or not Advocate Chauke's recommendation was PP'd or signed by him. I just want to know if the charge is referring to that particular document.
That is certainly one of the documents it will be referring to. I'm not sure if it's the only one.
All right, let me find the specific document right now, because you might help us on that. But the second question I have, I'll come back to this as soon as we find it.
I think I should try to find it as well. Chairperson, if I can get some assistance so that we have the documents ready through you, Chairperson. I'm not sure where these
Indeed.
documents are.
Yes, Madam. Advocate Halley, where's your junior? She doesn't appear to be here.
I believe
They're trying to find their documents.
She's trying to find the document.
Yes.
But I will obtain that document because I think I've got it.
No, my junior was quick on the mark. It's LO00780.
M
LO
LO
00780.
80.
Yes.
Is that an internal memo from Advocate Nokumashilu to Advocate Jiba?
Yes, Madam Chair.
Yes, thank you.
Yes. Dated the 15th of August, 2012. Now, the reason I ask...
May we wait for Advocate Batohi? Do you have it?
I do have it now.
You
Chair.
have it,
Yes.
Madam.
Now, the reason I ask Advocate Batohi is that it is the only document I could find that uses the word, I have perused the documents and recommend the application. And when you look at what is recommended, is at 1.3 are the draft authorizations for Section 2.1E and 2.1F of POCA. Is that what you are referring to in 3.1.1.2?
This is definitely what we are referring to.
All right, that's fine. We can note that that's the document you are referring to.
I didn't say it's the only document, but it
Well,
is a document that
show
we're
us
referring to.
any other document.
I'm
that-
not sure if it's shown to me, then I might be able to comment on it.
Well, in your evidence in chief, you did not make reference to any other document. In our own search, we did not find any other document where there is a recommendation for the signature of the racketeering authorization, other than that document that involves Advocate Chauke.
I think there's another document that's prepared in his name, but is not signed by him.
Yes, exactly. That is the only document that he signed. I know what I'm asking you.
Mhm.
So I come back to my question. This is the only document we could find that is signed by Advocate Chauke.
Relating to the racketeering authorization.
Well, that is obvious, Advocate Batohi, please, because I am talking about 3.1.1.2, which is about the racketeering authorization.
No, with all due respect, I don't want to take, things may not be that obvious. So I want to make sure when I answer, we're
All
clear
right,
about what
I
I'm answering.
apologize. Yes, the answer is yes.
So in this case, it does relate to the authorizations for racketeering. That's correct.
Yes. Well, let's make this clear because I Advocate Chauke, which reference authorization under Section 2, subsection 4 of POCA. Is that correct?
That's my recollection.
Yes. Thank you very much. Now, with staying on 3.1.1.2, that charge has nothing to do with the predicate offenses independently. I understand that predicate offenses are part of POCA, but it has nothing to do with the separate charges. It's limited only to Section 2.4. Is that correct?
That's correct.
Yes, thank you. Now, if we could also analyze 3.1.1.3.
Mhm.
It says Mr. Chauke sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that he finalized the answering affidavit of the then acting National Director of Public Prosecutions, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, is it the case of the NPA that when it says Mr. Chauke defended those proceedings, it is referring to the role he played in the preparation of the answering affidavit of Advocate Jiba?
It is definitely that.
Yes. Yes, but there is nothing else. It is only that.
I'll have to think about the evidence carefully. I've laid a lot of evidence, and I don't want to concede that it's only this if I haven't really carefully considered what the evidence is. So I need to think about this.
You know, Advocate Batohi, you have spoken in this inquiry, I think, for 12 days. For you to say you still have to think carefully about the evidence really sends a negative signal.
That's your opinion, Advocate.
But I presume you have thought about the evidence you've given for the last 12 days.
I certainly, it's been something that has been consumed me for the past 12 days, but there's a lot of evidence. So I need to be careful when I say it's the only evidence because there's a line, so I need to think about this. I don't want to concede and then there's something else. So I should be allowed to think about this carefully.
I'm not asking you not to think about it, but I am putting to you that before you gave the evidence, you should have thought about it. You cannot be asking to think about it during cross-examination.
That's your view. I'm going to think about it anyway before I answer your question. So this is definitely one of the aspects of his defending the institution of racketeering. I'm trying to think about whether there's anything more in this respect.
Can I also assist you? The charge itself limits the factual basis to the finalization of the answering affidavit. It does not include any other thing.
If I may on that point say that the chapeau to these charges, if we want to call them charges, for want of a better word, states at 3.1, his direct or indirect conduct should be the direct or indirect conduct of Advocate Chauke relating to his fitness and propriety to hold office based on information, including but not limited to the matters related to the following allegations. And my point is that in as much as these attempt to set out or do set out conduct of Advocate Chauke in this context, it is not limited to this.
Well, this is what I'm debating with you, Advocate Batohi. What is the indirect conduct that is referenced?
So I need to think about all the evidence that I've provided thus far.
But I'm asking you, I'm putting to you that the charge is 3.1.1.3. You are saying in answer to me, no, look at indirect evidence. And I'm asking you, what is the indirect evidence?
With all due respect, I didn't say look at indirect evidence. What I said is that I was reading out the chapeau, and I said it states including but not limited to matters related to the following allegations. My point being not about indirect conduct, but about the fact that the allegations are not limited to what is set out in 3.1.1.1 until 3.1.1.5. That
Now,
was the
what
point.
are the other allegations that are not included? What we cannot have.
For example, the allegations relating to the signing of the Advocate Chauke's request for Advocate Malochwa to sign the indictment, that should have been included here.
Please, Advocate Batohi, we are at 3.1.1.3. At the stage at which Major General Boyson is in court, the NDPP is filing an answering affidavit. The charge tells us that its scope is the finalization of the answering affidavit. You are resisting my submission to you that that scope is limited. You're saying it's unlimited. I'm asking you, what are the other facts that support the defense of that review application?
I don't know for now if there are any other facts.
Thank you very much. Can we then go to a second aspect of that charge? You know, the last line, which starts with of racketeering charges against the accused.
I beg your pardon, Counsel, to interpose. The question that you asked Advocate Batohi in relation to the specific aspect, that is the scope of 3.1.3. Might we look at page 66 of the affidavit? It might help us. Page 66 of the record that contains your affidavit, paragraph 156. You have it, Advocate Batohi?
In a moment, Chairperson. Yes, I'm there.
Paragraph 156 of your affidavit gives us the essence of the allegations against Advocate Chauke. And for the purpose of the last question by Counsel, we may look at 156.4. You remember that?
I do,
You
Chairperson.
see that?
Mhm.
And by mere looking at paragraph 1556, giving us the essence
Mhm.
of those allegations against him, that is Advocate Chauke, the essence is there.
Mhm.
And it includes 1564 to the extent that he settled the affidavit of Advocate Jiba.
Mhm.
And there appears to be nothing more in that paragraph 156
Mhm.
as regards the question that is put to you.
Mhm.
Am I correct?
This is the essence of the allegations, indeed, Chairperson, which is summarized in this paragraph.
I am specifically referring to 156.4
Mhm.
as regards the question that is put to you regarding the conduct of the alleged conduct of Advocate Chauke in settling the answering affidavit of Advocate Jiba.
Mhm.
And I'm asking, is it correct that there is nothing more to this paragraph 156.4 in this affidavit? Your affidavit?
Chairperson, I'm not sure if there's nothing more because this was, as I said, summarizing the essence of the charges. I don't know if this is dealt with anywhere else in the affidavit.
This is your affidavit, counsel, with the greatest of respect to you. You should be able to help us because it is your testimony.
Mhm.
You should know this affidavit better than us. It is your affidavit under oath.
Mhm.
Otherwise, we are going to have to adjourn again and read this affidavit so that we ascertain whether there is any other part in your affidavit that makes reference to the further conduct of Advocate Chauke that is impugned.
I'm trying to go through the affidavit quickly, Chairperson, to the other sections and look at whether it was covered, because I know when we were drafting it, we dealt with the allegations and then we summarized the essence. So I suspect that it would be covered somewhere else as well.
I request the lady next to you and the junior counsel over there, if there is anything else that you might have picked that may be of help to Advocate Batohi, don't hesitate to bring it to her attention.
Yes, if they could check in the electronic version, it will be easier perhaps.
You may quickly, counsel, look at the electronic version.
I'm advised 146 might be applicable. 180. 180. 180.
I think 146 is just a replica of what is stated in 156, the essence
Okay,
of the two.
146.
146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him. And that reiterates what appears as an essence at paragraph 1564.
That's correct, Chairperson. I'm checking 180 as well. Mm. 180.8, I think, Chairperson. Are those the only places? Those are the only three places. Okay. Those are the only other places that they can pick up electronically, Chairperson. And so we should accept that those are the only places where this is mentioned.
One
0.8.1.
8, page 76 of your affidavit. The heading there read, there is prima facie evidence that Advocate Chauke was complicit in the fraud and perjury charges leveled against him. And 188.1 reads, Chauke deposed to a confirmatory affidavit in the GCB case, where he confirmed that he finalized Advocate Jiba's answering affidavit before Groven's judgment gave rise to the fraud and perjury charges against Advocate Jiba. I suppose the point that you are referring to is the first line of 180.8.1. That again, and not necessarily so, that he deposed to a confirmatory affidavit, supposedly following the answering affidavit that you relied upon earlier. Is it a different matter?
No, it's the same matter, Chairperson.
Thank you.
Thank you, Madam Chair. I think could we just come back to this topic, because I'm just not sure if there is any difference. Let's start with 3.1.1.3, which is the charge. Okay. Now the charge says you sought to defend the institution of the aforementioned racketeering charges in the review proceedings brought by Major General Boysen to have the said racketeering charges set aside, and that you finalized the answering affidavit of the then acting National Director, Advocate Nomgcobo Jiba, in the Boysen review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of the racketeering charges against the accused. Now, my question to you was, my reading of this charge is that the scope of that charge is limited to the role Mr. Chauke played in the preparation of the answering affidavit of Advocate Jiba. Your answer was no, it may be broader than that. That's where the discussion started. Now, the chair then intervened to say perhaps your affidavit can shed more light. Now, let's look at each of the paragraphs you've now cited, starting with 146. Now, paragraph 146 reads, in response, Jiba deposed to an answering affidavit. This affidavit was, according to Advocate Chauke himself, finalized by him, would you accept that that is the same as 3.1.1.3? It does not add any additional facts.
That's correct.
Yes. Now let's go to paragraph 156. Now, paragraph 156, the relevant part, as pointed out by the chair, is 156.4, which says he settled the affidavit of Jiba, and the allegations contained in Jiba's affidavit were found to be false, and as such, he had made himself party to those false allegations. But the conduct is still the same. It's the role he played in the finalization of the answering affidavit. Is that correct?
That's correct.
And then the last one is paragraph 180.8.1, which reads, Chauke deposed to a confirmatory, should be a confirmatory affidavit, in the GCB case where he confirmed that he finalized Advocate Jiba's answering affidavit before Governor J. Govern's judgment gave rise to the fraud and perjury charges against Advocate Jiba. Again, would you accept that the conduct is still the same? It's the role of Mr. Chauke in the finalization of the affidavit by Advocate Jiba.
That's correct.
Yes. We can then come back to where I started. There is no other case that Advocate Chauke is other than the role that he played in the finalization of the answering affidavit of Advocate Jiba. Is that not correct?
Yes, let me just say that there's different actions that Advocate Chauke took in this process. For example, liaising with the team and Advocate Hodes, but it's all in relation to the finalization of this affidavit.
Yes, but I've never asked you about those sub-steps. I asked you that the conduct you are worried about is the role he played in the finalization of the answering affidavit. Obviously, he did many things, including signing a confirmatory affidavit. But what I want us to agree about is that that charge, the scope of it, is limited to the role he played in the preparation of the answering affidavit.
I'm trying to answer this in a way that conveys not precisely, because it's difficult to be precise, but conveys the full scope as has been put to me of his conduct in defending the racketeering charges. Certainly the finalization of the answering affidavit is an important aspect of that conduct, and is the one that is referred to in this subparagraph, or 3.1.1.3. And I hear Advocate Nkabinde saying that he doesn't want the steps, but it relates to the scope. That's the conduct broadly. And so to that extent, I can agree that it relates to that conduct.
Yes, now, thank you. Now, the charge is even more limited because it is about the finalization of the answering affidavit. Now, you have other things you wish to add to the charge, but they're not in the charge.
So as I mentioned earlier, I have testified about what I know and what I've experienced and what I've found in this process. And I'm not attempting to add anything. I am giving evidence. And in my view, it is because of the chapeau 3.1, what I'm saying is admissible and should be considered, because these sub-paragraphs, if you want to call it that, 3.1.125, are not limited. And so I'm giving evidence about what I know and what I've experienced, and that's all I can do here.
Advocate Batohi, you are still not answering my question. The question is straightforward. That charge, I know the word charge is a strong word, but it was introduced, thankfully for all of us, by the chair, refers to the finalization of the answering affidavit. Doesn't refer to these other steps you are talking about.
But it includes them.
Where does 3.1.1.3 include them?
I said the chapeau includes them.
Yes. So the preamble.
Yes, 3.1.
Yes. Now, we are still to look at what the draft was. Because it seems to me that the simplest thing would have been to tell Mr. Chauke that you are accused of preparing the answering affidavit. You are also accused of the following preparatory steps, because that is all information that was within your knowledge when these charges were prepared. Is that not correct?
It was within my knowledge, that's correct.
Yes. And now, why don't you include it in 3.1.1.3?
If we wanted to include everything, we would have had to include Dr. Broughton's bundle as the charge sheet, because it has lots of conduct of Advocate Chauke that would fit into some of these, like his role in preparing the answering affidavit.
But Advocate Batohi, I'm asking you about one aspect. I've not even come close to Dr. Broughton. I'm asking you about the preparatory steps that you have sought to add to 3.1.1.3. Why were they not reflected? It would have been one sentence in 3.1.1.3.
I can't answer why it was not included, but that's
Yes.
my evidence.
Thank you very much. Then I said to you that there was a further aspect of this charge when in my analysis I couldn't understand. It talks at the end, in the last line, with racketeering charges against the accused. Now, on the one hand, it may appear to refer to all of the accused. And on the other, it may appear to refer only to Major General Boyson. Does it refer to Major General Boyson only, or does it refer to all of the accused?
I'm looking at the context of this charge, and well, for want of a better word, and the way it's framed in order to answer your question. It says here, he finalized the answering affidavit of the then acting NDPP Advocate Chiba in the Boyson review proceedings in opposing the review application, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused. Now, given that it is referring to the Boyson review application, my interpretation of that would be that it refers to Boyson alone.
All right. So unlike 3.1.1.1, which you said refers to all of the accused, 3.1.1.1.3 refers only to Major General Boyson.
Yes, that is correct.
Yes. And can you explain why it did not say against Major General Boyson?
I can't.
Because that, again, would have been a very simple insertion. You would accept that?
To the extent that it's relevant, it would be a simple insertion. But
Well,
it doesn't make a difference to what's said there.
Well, okay, let's talk about the relevance. It's clearly relevant to tell Mr. Advocate Chauke what the scope of the allegation is. And if the scope is limited to Major General Boyson, it's relevant to tell him that. Wouldn't you accept that?
Well, in this context, it is telling him that.
Yes. Now, if you look at 3.1.1.4,
Marcel, before you go there, and Advocate Batohi, this is just a clarity-seeking exercise on my part. Whilst we are still on 3.1.1.3, look at paragraph 142 of your affidavit. It's on page 60.
Mhm.
This paragraph refers to the unlawful action on the part of Advocate Chauke as the de facto DPP. You remember?
Mhm. I do.
That was your evidence. And now, when we unpack this allegation or this statement on your part relating to the unlawfulness or the alleged unlawfulness on his part, I suppose we should then go to the terms of reference 3.1.1.3 that we've just been talking about, and try to relate it to what you allege to be an unlawful action on his part. If one were to look at 3.1.1.3 regarding his having finalized or settled the answering affidavit on behalf of Advocate Jiva to defend the review application, will that per se constitute an unlawful action? Put differently, will the mere settling of an affidavit on behalf of the head of the NPA in itself constitute an unlawful action? Because what I seek to understand is precisely what is this unlawfulness that you are referring to. Is my question clear to you?
Reasonably, Chairperson.
I beg your pardon?
Reasonably clear. I will try to answer it. Chairperson, the unlawfulness of Advocate Chauke's conduct is all actions he took in the context of this matter, particularly relating to prosecutorial decisions, as the de facto DPP in this matter. Those actions that he would have taken in that context would be unlawful. This particular act of finalizing an affidavit, generally, it would not be, in fact, DPPs would be involved in such actions for a national director to settle affidavits. But if in the settling of the affidavit, you are actually taking a prosecutorial decision to appeal a matter or to recommend to the NDPP that this matter be appealed on the basis of the contents, or not appealed, the matter be opposed on the basis of what is contained in the answering affidavit, then in my view, that amounts to his role as the de facto DPP and would in fact also be something that a decision a prosecutor would take in terms of opposing an application. And in that sense, it would be unlawful conduct.
It's kind of a long answer, but I just want to ascertain from you whether that single act in relation to 3.1.3 of the terms of reference specifically reflected as I quote, he finalized the answering affidavit of the then acting national director of the public prosecutions, Advocate Nomgcobo Jiba, in the Boyson's review proceedings. It is that act just to focus on, understand whether the allegation of unlawfulness in your affidavit at paragraph 142 covers that limited aspect of the terms of reference that I have just read to you. Let's not talk about anything else because I assume they will deal with further decision. I just want to clarify in my mind whether this act of settling an answering affidavit on behalf of the head of the NPA in itself constitute an unlawful action.
Chairperson, my answer to that is yes, it does. For the following reason, that a decision to oppose a review application is a prosecutorial decision. And that decision to oppose was taken by Advocate Chauke and supported by him as reflected in the contents of the affidavit that he settled.
And that affidavit that he settled is not his affidavit. It is under the signature of the head of the NPA.
That's correct.
Who will take the rap for whatever is in that affidavit, irrespective of who settled it?
That's correct.
Am I correct?
Well, that's correct. She will take the rap for it to the extent that, there's anything unlawful about that. If there is.
No. I just want to ascertain from you as to, even if somebody drafts something for you as the head of the NPA and you append your signature ultimately on that very document, it is you who's going to be accountable for whatever appears in the document that you sign.
Yes, Chairperson, to the extent with regard to the conduct of the signatory to an affidavit, you will be, but here we're looking at the conduct of Advocate Chauke before that in taking a prosecutorial decision.
I'm not asking about that, Counsel. I'm just talking about a simple thing in relation to signature and the impact of your signature on a document, irrespective of who drafted it, that you finally apply your mind to the content of the document and decide if you align yourself with its content. That's what I'm trying to ascertain with you. That finally, irrespective of who proposed, who advised, who drafted it, you are the final decision maker in relation to the contents of this very document. That's what I'm just trying to ascertain.
That's correct, Chairperson.
Yes, thank you.
Thank you, Chair. Advocate Batohi, I am still on 3.1.1.4. And perhaps to close off on the discussion you've had with the Chair, I understood that you accepted that the entirety of 3.1.1 is about racketeering. And you also accepted that racketeering is within the exclusive power of the NDPP. Was I correct?
Sorry, what section? 3.1 point?
Point 1, all of those sub-paragraphs are about racketeering.
That's correct.
And racketeering is within the exclusive power of the NDPP.
That is correct.
Now, I'll go through now to 3.1.1.4, but just to close off on what the chair has asked you. There is no charge that I have seen here that accuses Advocate Chauke of acting outside of his jurisdiction, particularly on racketeering, which is the exclusive power of the NDPP.
I need to check this, Chairperson, if you give me a minute. Yes, there's nothing here that says he acted outside of his jurisdiction.
Thank you. Can we then move on to 3.1.1.4? And again, just to remind you, the exercise I'm doing now is to analyze the charge to ascertain precisely what is the scope. It says you instituted, I'm inserting you instituted, an appeal against the judgment of Judge Govan in the review case of Boysen versus acting NDPP without the approval of then National Director of Public Prosecutions, Mr. Mxolisi Nxasana, notwithstanding that there was no evidence justifying the institution of racketeering charges against the accused and no justification for lodging an appeal against the judgment. Now, you have not referred us to any record indicating the decision by Mr. Chauke to institute the appeal. And perhaps you can come back on that on Thursday when you go through the record.
I can try to deal with it now.
All right, carry on.
To the extent that I can. I certainly won't have time to look at the record between now and Thursday. The issue is that the matter of the appeal against the Govan judgment, certainly Mr. Nxasana, if he is called, will be able to give clarity on this. But my understanding is that I think Advocate Chauke's response to the president might help us in this regard. If I could just have a look at that. Do we have that letter? If you'll bear with me, Chairperson, I just think there's something about this in this letter. Yeah, paragraph 42 deals with his response to the president, Chairperson. If I could just read it, it might help me. Should I read it aloud, Chairperson, or just to myself?
You may, ma'am.
Thank you, Chairperson. Mr. President, following the judgment from the High Court, the prosecution team received a recommendation from Holders SC, who represented the NPA in the review application, that there were good prospects of success in the appeal. Advocate Holders expressed a concern that considering that the days for the lodgement of the application for leave to appeal were soon to expire, it would be advisable to provisionally lodge the application pending the final authorization from the NDPP, so as to avoid the compilation of having to seek condonation if the NDPP were to decide to pursue the appeal, and that if the NDPP decided against the appeal, it would simply be withdrawn. I was present at the meeting at which this was discussed. My reading of this then would be that Advocate Chauke decided to, as it says, provisionally or advise or instruct, I should say, because it would be the instruction, Advocate Hodis would only act on the instruction of the NPA, to provisionally lodge the application pending authorization from the NDPP, which means that at that point, there was no authorization from the NDPP to do this. But Advocate Chauke indicates reasons why they needed to move quickly because of the DS. And so in my reading of that, it would be his instructing Advocate Hodis to institute the appeal. Yes, thank you, Chairperson. That's my response.
Well, I honestly do not understand what you have just said. My question is simple. You have not referred us to a single document in which it is recorded that it was Advocate Chauke's decision to institute an appeal. Paragraph 42 does not say that.
In my view, it does.
Show me the words there which says it was my decision to institute the appeal.
It's my reading of that section that my conclusion, well, my reading of this is that Advocate Chauke decided to advise Advocate Hodis to provisionally lodge the application, which in my view is instituting the appeal.
So,
But of course, he says pending the authorization of the NDPP.
so even though the paragraph does not say, I instructed the institution of the appeal, you decided to read it as meaning that that is what it says.
From the evidence, we know that the appeal was in fact lodged.
That is not the issue. The issue is whose decision was it? You have charged Mr. Chauke as the person who made the decision. I am looking to see the factual basis for the charge, which presumably you would have had even before Mr. Chauke made representations to the president.
The factual basis is that Advocate Chauke, as the de facto DPP in this matter, met with Advocate Hodis, and after that meeting, there was an appeal that was lodged. And in my reading of that, it was on his instructions, because if you read further, he then briefed on paragraph 40. Well, at paragraph 43, he says he briefed Dr. Ramaite on the recommendation we had received from counsel. He expected, I'm paraphrasing, Dr. Ramaite to brief the NDPP. That is my reading of the evidence.
Now, Advocate Batohi, please help us here. This paragraph 42 and 43 are things that happen way after you have recommended to the minister that Mr. Chauke must be charged for bringing the appeal. At that stage, when you took the decision, you must have had a factual basis. Point us to it.
It's in the evidence bundle, Dr. Broughton's affidavit and the evidence. My recollection in summary, as I mentioned, and I will mention again, is that Advocate Chauke, if I'm not mistaken, there was a prosecution memorandum that was drafted in support of the appeal. He met with Advocate Hodis, and thereafter there was an appeal that was lodged. without the NDPP's approval. In my understanding of that, Advocate Holders would have acted on the instructions of Advocate Chauke.
Yes. All right. So as matters stand, you are relying exclusively on the report of Dr. Broughton. You are not relying on any objective memorandum signed at the time to instruct the institution of the appeal.
Dr. Broughton's report has the evidence attached to it. So I am talking about his report, which has a comprehensive dossier of evidence, which is about a lever arch, maybe more than that. I think it's a lever arch and a half full of the evidence. So I looked at documents and the evidence and not just what Dr. Broughton said.
All right. So as I understand then, again, to try and define the scope of the charge, you are saying if we read the report of Dr. Broughton, we will find there a document prepared by Advocate Chauke which instructs the lodgement of the leave to appeal.
It's not what I said.
Well, I thought that's what we've been discussing for the last 5 minutes.
We have been.
So then, when I asked you to exclude the report to the minister because it came after your decision, and you said, well, look at Dr. Broughton, and I'm now asking you whether it is your evidence that Dr. Broughton has attached to his report documentary proof of an instruction from Mr. Chauke. Are we going to find it or not? Very simple.
You will not find a document of that nature.
Yes, all right. Thank you very much. Now, I just want to go to the analysis of 3.1.1.5. It is alleged in this charge that you, Mr. Chauke, attempted to have racketeering charges against Major General Boyson and members of the Cato Manor unit reinstated by the then National Director of Public Prosecutions, Mr. Nxasan, notwithstanding that there was no evidence justifying the institution of racketeering against the accused. Now, I have 3 questions. The first is whether or not this charge is limited to racketeering or includes the independent subsidiary offenses.
It's limited to racketeering, in my understanding.
Thank you. The second is whether or not this charge suggests that there was no case of racketeering for everyone, not just Major General Boyson.
It does. Well, let me read that quickly before I respond so fast. It does.
Yes. The third one is, on what basis do you say it was Advocate Chauke who attempted to have the charges reinstated? Just show me the document where he tried to do that.
I'm trying to recall the evidence of what Advocate Chauke did after Advocate Nxasana was appointed. And I can't recall it at the moment, what exactly the evidence is in that regard.
You can't recall.
I can't recall what the evidence is in this regard.
Yes, I understand. But it's unfair to ask you to recall all of the evidence.
Thank you very
But
much. I appreciate that.
I can ask you to recall at least one thing, which is, on what basis did you suggest that it was Advocate Chauke who attempted to reinstate the charges? Surely you must recall that.
I can't recall what his conduct was at that point regarding what happened when, but for the appeal aspect, I'm not sure what more Advocate Chauke did. What I do know is Mr. Ngasana at some point asked Advocate Chauke, after he raised the issue of him exercising, well, I'm not sure how it was exactly put, but the fact that Advocate Chauke had no jurisdiction in KZN, and he then said that this matter must be dealt with by Advocate Noko. That's what I recall. So I can't, besides that, I don't know what exactly he would have done to have these charges reinstated after Mr. Ngasana was appointed.
Yes. Because it seems
If
to
there's
me,
any evidence, it will speak for itself. As I said, I'm testifying about things that happened when I was not even there. So it's about the evidence that should speak and not my trying to recall what the evidence was. That's what the idea of this fact-finding is.
you see, Advocate Batohi, it seems there are two independent acts that are being conflated. The first one is whether there was ever any attempt to bring life to these charges under Advocate Ngasana. The second is whether Advocate Chauke was involved at all. As I understand, you can't help us on either.
I can't, but hopefully the evidence leader can look into this. And if there's any evidence that needs to be led, any facts that needs to be brought to the attention of this panel, it will be done. If there isn't anything, that's the position.
Can you recall when Advocate Ngasana assumed the office of NDPP?
No.
If you go to LO 00886,
Advocate Batohi?
thank you, Madam Chair.
Please repeat that.
LO 00886. There is an email of the 11th of April 2014 at 2:51 p.m. from Mr. Chauke to Dr. Ramaite. Can you see it?
See one at 3:20 to
Yes, there
51.
is one below that.
To Dr. Ramaite.
Yes.
Yes, I see that,
Now,
251.
Mr. Chauke says, I refer you to the comments and reservations of both the NDPP and yourself regarding my involvement in the Cato Manor matter. I refer also to a subsequent meeting that I held with the NDPP on 8 April 2014. I hereby confirm that I will no longer take part in any way regarding the management and prosecution of this matter. I have accordingly informed the team leader, Advocate Mayema, and the DPP KZN Advocate Noko. That is dated the 11th of April 2014, referencing a meeting with Advocate Ngasana on the 8th of April 2014, where Mr. Chauke says he will no longer participate in any manner whatsoever on Cato Manor. So surely your evidence on 3.1.1.5 must show us that after this date, Advocate Chauke attempted to have the racketeering charges reinstated.
As I said, I'm not the only witness in this matter. I don't know what the evidence is going to show.
Well,
Please, repeat the question, and if you can just try maybe to confine yourself to the question that has been asked. If you know, yes. If you don't know, no. So that we obviously know your stance about this question.
Yes.
Because I'm not sure how you are answering it, Advocate Batohi. Please repeat the question.
Thank you, Madam Chair. Advocate Batohi, I referred you to the email of the 11th of April 2014 at 2:51 p.m. written by Advocate Chauke to Dr. Ramaite, in which Advocate Chauke says, bearing in mind the discomfort of the NDPP, which was expressed in the meeting of the 8th of April 2014, he withdrew from involvement in any manner on the Cato Mano case. Now the question is, surely to establish 3.1.1.5, you would need to produce evidence that after the date of the 8th of April 2014, Advocate Chauke attempted to have the charges reinstated.
My response to that is I don't need to produce the evidence leader needs to. I will testify about what I know, what evidence there is. I don't know what happened after that.
All right, let me not say you need to. Let me ask you, do you have the evidence?
As I sit here, I don't have any evidence.
All right, thank you very much. Could I then try and do an analysis of the following charge?
Just for clarity, and it is the evidence in relation to the alleged attempt to
Yes.
reinstitute
Yes, Madam Chair.
the
Correct.
racketeering charges.
Yes, correct. Now, could I also just try to analyze 3.1.2? That is the Mr. Mdluli charge. Now, could I just understand the scope of this charge again? Now, I'm going to reference a discussion that you had with panel member Ramachakha. When she asked you about the charge, particularly with the use of the word "in that" as suggesting a limitation of the scope of the charge, you said in your response, maybe these terms of reference must be amended. Can you explain why you said that?
I can't remember the context of that particular question. Let me read this and see try to gauge what I might have meant by that. To the extent that this is not complete in terms of the conduct of Advocate Chauke's that we complain of, I would have possibly meant that it should be amended to include his conduct not just at the point of withdrawal of the charges initially and submitting it to an inquest, but also his conduct after that, after the inquest hearings, they were hearings, after the inquest process was completed, his conduct his conduct in coming to a conclusion that the magistrate found no evidence implicating General Mdluli when that was incorrect. The magistrate's findings were confusing and contradictory. So in that regard, Advocate Chauke at that point ought to have reconsidered the matter given two things. One is that the prosecution team said there was strong evidence against General Mdluli. The fact that the magistrate's findings were confusing, and also the fact that the representations of General Mdluli was a fanciful conspiracy. So that's the next point of decision making. Thereafter, Advocate Chauke's conduct after the Mdluli, the Murphy judgment, when Judge Murphy was very critical of the conduct of Advocate Chauke, and
comment. As you know, because Mr. Chauke has made representations, he says he was uncertain about the strength of the evidence. Is it your case that a prosecutor does not need to be certain about the strength of the evidence?
that's not my case. That's what Advocate Chauke says.
No, I understand that his justification is that he was uncertain. I'm asking you why he is being charged. Is he being charged because you are saying a prosecutor does not need to be certain about the evidence before they enroll a matter.
That is not the reason why he's being charged.
But what is your answer to my question? Are you saying that the prosecutor does or does not need to be certain about the evidence before they put the matter for a charge?
A prosecutor must be certain of the evidence.
Yes. Now,
Perhaps, Counsel Advocate Batohi, are you suggesting, as regards the evidence that is to be presented at the trial, at the state of charging, a prosecutor must be certain of all the evidence that needs to be presented to prove the charge? Is my understanding correct? Or should there be merely a prima facie evidence to institute that charge? If you can clarify that to me, or clarify your answer to Advocate Nkabinde.
Person, yes, thank you for that question. I'm not suggesting that at the point, because at that point it could in fact be prima facie evidence. It could be a situation where a person has been charged because there's sufficient evidence to charge, but at that point you should be certain of that level, whether it's prima facie. You must be certain that you have sufficient basis to charge the accused at that point. It doesn't mean that it will be all the evidence, because investigations could continue and more evidence could be gathered. So, but I think the question that I was answering to Advocate Nkabinde was slightly different. My understanding of his question is that if a prosecutor, well, put conversely, is uncertain of the evidence, should you charge? And my answer to that was no, you should not.
Thank you.
thank you. Well, it seems you've given inconsistent answers to my question and the chairperson's question, which are effectively the same question. Maybe let me give you a chance to clarify. What should a prosecutor be certain about? What is he allowed to be uncertain about before he makes a decision to charge?
Well, firstly, let me say I have not given inconsistent answers. I've answered different questions. And to your question, and the record will show, we can go back. Your question was, put conversely, whether a prosecutor should enroll a case if he is not certain of the evidence. And I said, no, that should not be the case. The chairperson's question went further and asked whether at the stage of charging, a prosecutor must be certain of all the evidence, and whether shouldn't there be a prima facie evidence. And my answer to that was that when a prosecutor charges, they need to be certain that at that point, it meets the standard that is required for the enrollment of a matter. That could be either at the level of prima facie evidence, which is completely in order for you to enroll it, but that doesn't mean you are certain of all the evidence, because there could be evidence that is obtained after that. So I hope I'm clarifying. In my view, I'm not giving inconsistent answers because the questions were slightly different.
Yes, thank you very much. Now, could I also ask you about the relations in relation to the Mr. Mdluli matter? Is it correct that you relied exclusively on the memorandum by Advocate Gathali SC?
That's not correct.
What else did you rely on?
Prior to me asking for his opinion, I had received the opinion of Advocate Nalane, who recommended that this be one of the matters that be included in any referral to the president. I had Advocate Chauke's response to that in his in the form of Advocate Maineche's opinion. I think I must just look at my letter that I sent to Advocate Chauke before I respond further, to make sure that I am clear that my recollection of what happened a couple of years ago is correct. The letter to, is it in here? Okay. Might be an attachment to my affidavit, Chairperson.
Is it when you requested Advocate Chauke to present further information?
On the 5 matters.
I beg your pardon, may I finish?
My apologies.
In a document attached to your affidavit, SB6 at 240, and I'm not sure whether this is a document where you requested for further information relating to the decision made by you as the DPP Gauteng Johannesburg, and Advocate Chauke then responded from SB 6241. Is that a document?
Yes, I think it's SB5, Chairperson. Just check that now.
You see, the one that I'm referring you to, just let's deal with the one that I'm referring you to first. That one is SB 6241, attached to your affidavit. Those additional documents that you filed of record, and in the first heading, he deals with the Richard Mdluli murder case and the related charges. Is that the document you wish to refer to?
No, Chairperson.
Okay, let's look at SB 5 that you referred us to then. Only SB 5 that I have here is your request to Advocate Chauke, SB 5231.
That's correct.
Which then culminated in his response at SB 6.
That's correct.
The SB 5, is that the one that you're looking at, your request to him?
That's correct.
Yes.
I'm looking at paragraph 2 on page 232. So I had access to documentation in a file. I had a 2.2, there was a decision, a court decision. In fact, there would have been all the decisions. It would have been the Judge Murphy decision as well as the SCA Brandt decision, as I set out. So I would have had also Advocate Chauke's response to this matter in SB 6. I think that's all the information I would have had. That's the information I would have had before the opinion from Advocate Hali.
Yeah, we noticed that it's now past 12 o'clock. Okay.
It's 12:03.
Yeah, it's past 12 o'clock. Okay.
Thank you for reminding us, because I cannot be late for my appointment.
I had actually thought that maybe I should find out, Council, whether you are ending it up at General Mdluli's point, the terms of reference 3.2, or you want to exhaust this question before we step out?
Chairperson, may I please comment on that? Well, let's hear what Advocate Nkabinde says first.
That's fair, because I'm asking him the question, not yourself. Shouldn't you wrap up, or you want to tie it up?
Madam Chair, I can stop now, but it's not a convenient place, but the agreement was that we would cut off at 12, so I should stick to that.
Advocate Batohi, as Council mentions, it may not be a very convenient point to leave the questions hanging, but given your request, we will, I see you anticipate what I'm going to say. We'll definitely adjourn, because we bear in mind your earlier request that you be afforded an opportunity to go and attend to your personal matter.
Thank you, Chairperson.
So you need not change your face, because
Thank you, Chairperson. I'm only human.
we are going to adjourn to keep our undertaking to enable you, as per your request, to adjourn now until Thursday morning. To all concerned, Council, Advocate Batohi, we will adjourn and reconvene on Thursday morning, the 11th at 9 o'clock. In the meantime, we will request that we be finished with the document that was to be provided earlier, so that when we reconvene, we would have had a look at it. Please instruct your team to file that document or give us copies.
Thank you. I'm indebted to the panel.
We will adjourn until the 11th of December, Thursday at 9 o'clock.